Good morning, Ben.
Good morning, Doc. Good to see you.
Good to see you too. Now, Ben, I am confused. Did my country, Ghana, represented by my government, win at the arbitration tribunal, or did my country lose?
Yeah, I think you simplified the question enough, and the answer is that Ghana lost the case in court, and the case essentially was to prove that the unitization order was premature. It was not in sync, even with our own laws and also industry practice. And that, for me, is what the court ruled on. And to that extent, there is no other interpretation to the subject matter that was before the arbitral tribunal than to say that Ghana lost the case, and the claimants or those who took the matter to the court actually won on that.
Now, Ben, we'll get to some consequential claims that appear to have been made by those who went to the tribunal, and of course, even the respondents. But my digging on the issue shows that some time back, you, in the CSO space, well-versed in the energy sector, saw a looming problem and even had to write to His Excellency the President for his intervention on the matter. Can you shed some light on this and why you did this years back?
Yeah, no, I think when the matter was raging, we had commented on it lightly on many fora, trying to draw attention to industry practice and how unitization actually happens. Our thinking was that, well, if it was possible to unitize the blocks and was commercially sensible to do so, Ghana benefits for it. But to be able to determine whether it is appropriate to unitize, there are scientific ways of determining that and actually proving beyond reasonable doubt that in unitizing the fields, Ghana stands to benefit, and not necessarily just bringing more people to the party to take the benefits away. So in that patriotic duty of ensuring that the state interest is enforced, or we were protecting the interests of the state, we kept engaging, we kept writing, we kept pushing government to do the needful. Make sure that the decision that you are taking actually increases the national take. Ultimately, by unitizing, the revenue to the state should increase. So if you have not proven that the state will benefit more, then you are not doing what will be in the interest of the state. And because the ministries and government agencies will not listen, we thought that, let's seek the attention of the number one gentleman of the land to state that even if you had all the advice you wanted from your cabinet, from the energy ministry, from the attorney general, and everybody involved, there are many experts in the space. It costs far less to seek that opinion and not take Ghana through that path that we're going. And also realizing that that singular decision to cause the unitization was causing Ghana significant harm, because a lot of investors were apprehensive. Sustenance capital was impacted because they were not putting in their money. They were not sure what the outcome of that directive was going to be. And also there were local rulings that was further disturbing the oil and gas industry, because every investor was then looking at how would Ghana interpret its laws when there are issues, there are concerns with the investments that they would have made. And mind you, this is a $7 billion investment that the partners have made, and they need to recover that investment. And suddenly, somebody says, we want others on the party, without proving why they should be part of a transaction. So we thought that we needed a hearing of the president for at least making sure that the right things are done, and that Ghana didn't need to go to arbitration on a matter that could be proven scientifically. And there are scientific methods of ensuring that the unitization is right and it is done properly. And that was what we basically sought to do, to really alert the president that it was premature. We didn't need to do what we're doing. We didn't need to go to arbitration when the cost of actually determining whether the unitization was proper was not significant, if you ask me, for us to waste Ghana's time, engage in those speculative activities that push all investors away. And now we have not even been able to assess the true damage that this has caused this country, because you are now assuming the investors that left, the investors that didn't put in their money, the relocation of businesses away from Ghana to neighboring countries as a result of these knee-jerk reactions and instructions. We've not been able to assess all these laws on us, and we thought that it was simply unnecessary and avoidable, for us to go that route. But it didn't amount to anything. We had to go arbitration, waste the money that we could have perhaps used to support the industry on litigation and pay lawyers for it.
Now, Ben, the tribunal refers to a portion of the petroleum agreement, which has been the case of ENI all this while. Now, what does that portion of the agreement say? And what does what it says mean?
I think they were just trying to alert the state of the stability agreement that they have with the government, and also to highlight that, if you want to do a unitization, you really need to prove scientifically that, it warrants it, all right, and not unilaterally decide that, we have to bring others to the party and not respond to those agreements. And also, essentially, the point of dispute or the jurisdiction for dispute is out of Ghana. So those references in the agreement, the state was supposed to be in full brief of what the law says, and even interpreting the industry law itself, which gives the power to the minister to unitize. And that power to unitize is not necessarily a substitute for the scientific proof that unitization should actually happen. But it was to ensure that after all the scientific methods had been applied, then the minister can go ahead and administratively instruct that they sanction the unitization of oil fields, and not to just say that before even the scientific methods have applied, we can establish commerciality on both sides. We can just, because there is unitization in the law, apply it. So they were drawing attention to the legalities in the contract and also in our own law, which were in total breach and did not, arise at the time that those directives were being instructed.
But Ben, I am a bit concerned about something, and it has to do with investor confidence. Now, we keep spending money on all platforms, all manner of fora, domestic, international, trying to woo investors into this country, especially in a capital intensive area like oil and gas. These investors seek to have some confidence in the fact that the country will respect contracts and provisions in contracts. But more importantly, these investors, the confidence that these investors will have in an economy is also on the basis or strength of their confidence in the judiciary of the said country. This is a matter that is gone through the judicial processes in this country. I remember that one of them even had a chief justice, a sitting chief justice, as head of the panel. Yet, all the rulings of the courts did not go the way of ENI. Now, they have had to go outside to the International Arbitration Tribunal, which then assets something which you would want to consider fundamental and basic. I mean, this clearly will have some serious implications.
Absolutely. I mean, the damage, to the country, if you assess it from all angles, is so significant. It brings in the courts and their rulings, which had no reference to the letter of the law itself, and also industry practice. They will just follow the directives of the minister and say the minister has said it and it has to be implemented that way. And if you have the courts subjecting investors to that kind of treatment, it makes it difficult for us to woo many other investors into the space. And that is why if you track how many roadshows we have done over the past couple of years and has brought in zero investment, we've just wasted the country's money. Because there is no better testimony of your capacity or of the robustness of your regime than the testimony of those who are already here. So if the testimony of those who are here has been that Ghana's investment climate is on a downwards dip, and investors are not treated right, laws are interpreted arbitrarily, all the way through the Supreme Court, you're not going to get an investment. And it was so basic for us to know that once we continued behaving that way, we're not going to get an investment that we were looking for. But perhaps the roadshows made sense because people would travel, per diems will be paid, and the state will spend money. And that was the outcome of what we have been spending money. The last count, we had done over 23 roadshows across the world, while the investors, those who are putting billions in our country, were struggling and complaining about the behavior of the state in our country. So that for me was really the problem. And how we reverse that kind of narrative, particularly when we have extended that behavior to the international court and there has been a ruling, how we reverse that at this point, for me, is the crucial thing for us to look at. And perhaps the way to do it is for an open declaration that we have been wrong over time, and going forward, investors' right, and people will come in and bring their money and will not be subjected to these kinds of treatment. Otherwise, nobody is sure what the next minister or the next president or the next attorney general would do. How do we bring that confidence back? I think it's a national conversation that we need to have.
At the heart of this issue are two distinct businesses. You have an indigenous company and you have an international company. Now, on the basis of this ruling, how do we move forward? What does the ruling mean? What is the impact? How do we move on?
Yeah, so now we will need, Springfield to go back to work. And we keep saying that if it is money you need to be able to improve on the commerciality or determination of commerciality of the fields, it's really about discussing with who has the money. All right. If you thought that E&I or the partners were the ones in the space that had the money to be able to do it, you engage and say, let's do it. It's business. And how you strike that out at that level is what is important. It's not hiding behind the capacity of the state to do the unthinkable. So I'm hoping that, common sense will prevail and that we would start engaging on how practically we can assess that discovery that was made to make sure that if there is indeed oil, that oil can be produced, for me, in the tiniest manner. And that is important. How quickly you can bring the oil on stream, particularly in this context of struggling economy. We need any revenue we can find. And if there is a resource that we can tap into, then we need to do that. And to do that, you need money, you need confidence, you need risk capital. And who brings in that risk capital? We need to engage the deep pockets. And you are lucky to have E&I, one of the global giants that in most cases dips into their pockets to bring money for development. Most of the oil companies like Tullow and the rest, they go to borrow to develop their fields. E&I is able to invest their own capital. So decision making is quick. And that's why they are suddenly making Cote d'Ivoire, the new oil hub, because they are investing money and they are discovering oil and they are producing in record times. So you need that kind of investor to be able to activate and add value to the space. And I think if they have common sense conversation with the investors to begin to test the discovery and make sure that if it is commercial, we can bring it on stream as quickly as possible. That could be done, but we are not even admitting that we have lost in court. So where does it start? Where does the conversation start? It's really between the government and the parties.
Now, Ben, the Attorney General tries to restrict us to the processes at the tribunal and to make us believe that to the extent that some of the consequential reliefs that E&I were seeking was not granted by the tribunal, we did not lose anything. You are a player in the industry. What is it that Ghana has lost as a result of this protracted litigation? Because obviously, if this unitization had been accepted and had happened, there obviously would have been revenues, hard-earned currency coming in over the period of the litigation.
Absolutely. I mean, the Attorney General knows clearly that E&I didn't go to court seeking $7 billion or even $1 million. They went to court, on the fact that the unitization was improper, and they won on that. What Ghana has lost, E&I estimated that to be around $915 million, dollars to them. So what that means is that if you do the composite loss to Ghana and to everybody else, that could be double that. All right. But the court ruled that because the unitization did not proceed or the directives did not materialize, they could not be entitled to that money. However, if Ghana continues with the directives, then that claims, becomes actionable, and they will be entitled to make those claims. And they even corrected the expert of the claimant when he said that, even though they estimate the claims to be around 9 million, they were not looking for 900 million, they were not looking for it. And the court says that could be wrong, because if they continue with the directive, then that claim, becomes actionable. So I don't see why we are focusing on the damages that were not granted, because that was not the core of the issue. The fact also remains that those directives were not implemented. If they had implemented directives, for example, stopped E&I from operating, we will be paying money today. The damages would have been granted in court. So that is the basic thing. We lost the substantive case. No cost was awarded against us. But in principle, the fact that sustenance capital was impacted, what that means is that the additional investment that they needed to make to improve oil recovery, produce more oil, produce more gas, the potential to tie back another discovery, the advanced discovery, which they thought was oil. They could do a quick tie back, produce more oil for Ghana, and it was rejected by the ministry because they thought they were in court with them. All of that would have brought in revenue, but they didn't happen. And those are facts. You may not admit that there are costs, but there are costs. There are revenues forgone. And that if we had allowed them to bring back or tie back that discovery, we probably will be producing an additional 100,000 barrels of oil today, but we are not. So those are costs that we can stretch to actually examine the impact of these directives on Ghana. And then if you begin to look at all other investment potential or actual that were withdrawn, you would then escalate the cost to Ghana beyond those numbers.
Right, Ben, thanks very much for your insight on the issue. I think that there's a lot more clarity on the matter. Thank you very much.